So a very good afternoon, my dear students. Those who are watching YouTube live, a very good afternoon to you as well. I hope someone is there. Ishwar is attending again. Mahesh, you have to help me. So, and hello, hi, good morning, good afternoon, good evening to those who will be watching this as a recorded session. All right. Nice, sir. Chat box, I box you. I hope all of you know Mahesh. Do you wish him? Do you greet him? Hello, Mahesh Anna. No, please do that. Everyone is a hero only, sir. They are also heroes. Make fun of anyone. If you really think he's a hero, I appreciate. If you're making fun, then please stop that. The part of our team, a daily basis, you see him, you meet him probably, you have some work also with him, right? He's the one who's making our classes smooth, right? We're able to start the class because of him. So he's an important part. He doesn't come one day, you'll know his value. Please understand that you should appreciate each and every one, especially those who are directly playing role in your life or indirectly. Directly I'm playing role, but indirectly he is, right? Yes, sir. You. So, once again, welcome, good morning, good afternoon, good evening to all of you. I hope all of you are doing good. I'm also doing good. Thank you so much. Yes, Govind, a very good afternoon. Yes, Ishwar, good afternoon. Good to see you there. Right. So, guys, before we start with anything new, as usual, we'll first try to recall what we have discussed in our previous session. Am I right? So, if you remember, in the last session, we talked about something relating to arrangement. Yes or no? Anything written in law is called as provision. So, we said all the provisos are provisions. All the provisos are provisions. But is it that every provision is a proviso? No, sir. How can that happen? Because proviso is an exception, a special case. So, general case, then special case we'll talk about, right? General rule, then we talk about exception. Am I right? Yes, great. Then I hope you remember how to read this. Section 4, subsection 1, clause D, subclause 2. Very good. Para A, subpara 1. Correct. Very good. Then when it comes to reading of law, we said, come on, we have to read primary legislation, secondary or subordinate legislation, and then sometimes even external resources. So primary legislation is the act, correct, the bare act, the act, but updated one, amended one, isn't it? And then rectified one as well, because there can be some errors, some mistakes also. Then rules, come on, primary legislation done, then secondary. So we'll talk about rules, notifications, circulars, orders, even, come on, case laws. Yes or no? Yes, sir. Like that, we know standards, dictionary, even other laws. When we are reading one law, we may refer to other laws as well, right? So the first one, if you just see in the list, is primary legislation, and where I have written from 2nd to 7th S, that is secondary legislation, and then obviously followed by external sources. So which example did I give you wherein I said that while reading one law, you may refer to other law? Very good. Maximum number of partners. So we said we will not refer Indian Partnership Act, but for that we'll refer Companies Act, because maximum number of partners is given in. Same way, if you remember another example I gave you, definition of minor. So while reading Indian Contract Act, we said we'll not get the definition of minor, rather we have to take it from, good, Indian Majority Act 1875. Very good. Then when we talk about the case laws, foreign case laws, when we talk about other laws, foreign laws, which one do we prefer? Which one do we prefer? English, right? English laws, English case laws, isn't it? I was telling you Solomon versus Solomon and Company Limited. So we are referring to foreign case laws as well. But which one do we prefer? The English, British case laws. Why so? I hope all of you know that. Britishers have ruled us, right, for almost 200 years. So then our laws are mainly inspired, right, from the English laws or by the, come on. So all of us know this reason, right? So we are not reading Canadian law or Swedish law and all, no. But we are referring to mainly British laws. Reason being, we are inspired from there. Technology helps in understanding law. Yes, sir. Like I was telling you, if notice has to be served by post, what does it mean? Only post? No, sir. It even means electronic mode, isn't it? We're talking about electronic mode as well. That's where technology. Then dictionary means Oxford dictionary, isn't it? No, sir. Dictionary meaning, we said the technical dictionary, the legal dictionary, isn't it? Apart from the English dictionary. Okay. Then when we talk about reading of a case law, citation matters. In citation we have parties, plaintiff, defendant. Then, come on guys, we also have the authority who has given that judgment, the year in which they gave the judgment, right? The journal in which the case is published, volume number sometimes, page number, and also hello. Thanks, Pawan. So we have got parties. In parties, we say we have two parties, plaintiff, defendant. Plaintiff meaning the one who files the case, the petitioner, the complainant, and defendant, the one against whom the case is filed, the respondent, the accused. Yes or no? Generally, onus of proof is on. Generally, onus of proof is on. You know the meaning of onus of proof? Burden of proving. Burden of proving. Someone answered correctly. Plaintiff. Very good. So generally, the burden of proving will be on the plaintiff, the person who is complaining, who is filing the petition. Okay. Onus means what? Burden. And as you know, never write anything. Correct? You get to know something new. You write, then what will happen? You'll revise. I've told you the other day. You revise, then you'll remember. You remember, you'll answer. Answer, drishti. Then you'll fall sick. Come on, my dear friends. I cannot tell you this on a daily basis that if you come across anything useful, you should write onus of proof. I thought you know the meaning. You don't know. So that means you have to write, revise it. Correct? Onus. What is the spelling of onus? We know it, sir. Know it better than you. Okay. Onus. That is burden. So burden of proof. Burden of proving. Okay. Right, sir. Then, come on. Talking further, we said in the case law we have obviously the subject matter on which the case is built or the case is involved. Facts of the case. The contention, intention, arguments, evidences, witnesses. And then comes the judgment. Right? Judgment is also called as decree, verdict, pronouncement. Am I right? Now please tell me, as a student, what do you bother about? Do you really bother about intention, contention of the parties? No, sir. We just see the citation. We see for what that case is, that means subject matter, and then directly we jump to decision. But practically when you are working, do you think you will bother about all this? Yes. Because if intention is different, facts are different, the judgment will also vary, will be different. Am I right? Great. Then we have discussed already, what is this AIR? The journal. The journal. I didn't ask you what it stands for. Okay, the journal in which the case is published. It might have volume numbers if there, then volume number also, and then page number, right? Apart from this, Asha, this year which is mentioned there is year of decision, not year of filing the suit. And then this 1461 which is written is page number, beginning. Good, beginning page number, not the end, right? So where the case begins is written in 1461, this case. Okay, then three bodies we talked about, right? Three bodies: legislature, executive, judiciary. Legislature makes law, executive implements law, judiciary resolves the conflict or helps in interpretation. Maybe people might even talk about the fourth body, that's where we also talked about it, that is press, which creates awareness. Good. Then fields in law, come on, the type of work which you will do can be grouped into three: compliances, advisory, litigation, or maybe representation. And lot of money is involved in compliances, isn't it? Good. No sir, lot of money is involved in, right? Ishwar, is it fine now? Those who are saying there's no voice, please confirm once. Are you able to hear me? Yes, now working. Okay, great. Now audible. Thank you. Thanks for confirming. Yeah, compliances, advisory, litigation, or representation. As we said, lesser money will be in compliances, but more money in obviously where you can save people, that is litigation or representation. Am I right? Yes, sir. Then generally we said section 1 comprises of title, extent, application, commencement date. Isn't it? Title may be long or short. Shweta, give me an example for long title. On fast, beta. And as soon as I call out your name, what are you supposed to do? Get up. Isn't it? That's a basic courtesy. Unless I say sit down. Sit. Huh? Long title, Indian Partnership Act 1932. Pawan? Very good. Foreign Exchange Management Act 1999. Managing foreign exchange. It's not just Foreign Exchange Act. So it's helping us in interpretation. Any title should help us in interpretation to some extent. Right? Surface Act. Again, long title. Isn't it? PMLA, Prevention of Money Laundering Act. Long title because it's helping us. SEBI is not long. SEBI Act. So that act is about SEBI. That's it. But what do we want to do there? We don't know. Isn't it? So Indian Contract Act, Indian Partnership, those are short titles. Clear? Right. Then we said, come on, definitions are there in section number 2. Generally or always? Generally. Then we even discussed some rules of interpretation. We said we don't just do literal interpretation, words as it is. We also go beyond the words, read between the lines as well. And that is what is reasonable interpretation. I hope you remember some examples we have already taken. Yes or no? Workmen Compensation Act. So during the course of employment, does it mean that person should go to office, sit on his chair, right, and start working? That is during course of employment? No, sir. Even on the road he is. This is called as during the course of employment. So it all depends upon the context and all. When do you go for reasonable interpretation? When do you shift yourself from literal to reasonable? When the objective is not achieved. Very good, Gayatri. Right? So when the objective is not achieved, that is where we move from literal interpretation to reasonable. Literal means words as it is, no change. Rule of grammar you will follow. But in reasonable, and will be interpreted as or as and, may as, shall as, may, etc. Also you will give some meaning. Yes or no? Plant and machinery. Plant, that means factory. How do you know? How do we know? Sir, with the help of the associated word machinery. Plant and trees. Plant, chotu, green color. Yes or no? Okay, then we started with some legal terms. We said let's understand some legal terms as well now itself. Isn't it? What are we discussing, guys? Basics of law and interpretation. Correct? We're trying to build our foundation. Then we said we'll go to the topic. Correct? So We have dealt with already a few words. Save, accept, no sir, accept. Then saving, sir, the previous position will continue. So new thing has come, but previous position will continue. That is saving. Correct? No? Then leave. Right. Then forthwith, immediate, in lieu of, instead of. Correct. Assent, approve. Dissent, disapprove. Till here we have discussed, I guess. Right? Let's discuss the remaining ones as well. So starting with the first one, which you could see on your screen, is, come on, overriding provision. Do you know what is overriding provision? And I hope you have written today's date. In case not, please write it. Please have the habit of writing the date and the day if you wish to. I don't know which day it is. I'm not talking about Monday, Tuesday. You know that. Right? Your dad's birthday, write dad's birthday. Happy birthday, Papa. Raksha Bandhan, then write Raksha Bandhan. Isn't it? Why? What sense does it make? Once you become CMA and people ask you, how did you become? What will you show? See now my book. On Raksha Bandhan also I attended the class. My dad's birthday also I attended the class. That much sincerity is required. That much of effort have to be put in. Then only you clear. Correct or not, guys? Jokes apart, that motivates us somewhere. Okay? I hope you remember your objective and you have done the overwriting there. Good. Those who have not done, please do it. Daily basis, overwrite that, manifest your objective, 60 plus, 70 plus, whatever it is, without fail. Now, overriding, that means it will override something else. Now, obviously, this is a provision. So, this provision will enjoy supremacy over other provisions. So, the provision which enjoys supremacy is called as overriding provision. Okay, the provision which enjoys supremacy. Okay, meaning will have priority over other provisions. So this provision becomes overriding provision. How do we identify that it is overriding provision? With the help of the prefix notwithstanding. Like how for proviso we have provided that, same way here in case of overriding provisions, what will we have? Notwithstanding. Okay, is white okay? White okay? Overriding provision is nothing but that provision which enjoys supremacy over other provisions and is also called as non-obstant clause. Okay, non-obstant clause, if someone says, it's the same thing. Now, I hope you are aware this overriding provision are of different types. Maybe you are reading some law, okay, some act. Section 65 is overriding. Let's say it is overriding. So it will be written notwithstanding anything contained in. Notwithstanding anything contained in, let's say 66. That means 65 is overriding 66. Or maybe notwithstanding anything contained in this chapter. That means all the provisions of this chapter. Okay. Or they might say notwithstanding anything contained in this act. That means this provision will override all the other provisions of this act. Notwithstanding anything contained in any law. That means it is overriding all the laws. We come across like this, no? So that means there are different types of overriding provision. A particular section, correct? A particular section or a particular chapter or a particular act or law or, come on, don't just look at the board, keep writing as well. All the laws. Isn't it? So there are different types of overriding provisions. See, why I am highlighting this before you is when we start reading, you should read properly. If it is notwithstanding anything contained in any law, that means it is like supreme, right, to all the laws. You have to be careful. If it is overriding only a particular provision, you should know that provision which obviously is not enjoying supremacy. Clear? Great. Then next comes subject to. Subject to. What does it mean? Sir, compliance of one depends on compliance of others. Compliance of one may depend upon others. Like if I have to give you an example, appointment of managerial person. Section 196 talks about appointment of managerial person, and it says appointment of managerial persons is subject to section 197 and schedule 5. Okay, is subject to 197 and schedule 5. So what does this mean? When can you say you have complied with 196? Only when you have complied with 197 as well as schedule 5, otherwise not. Otherwise not. You understand what I'm saying? All of you? Right. So guys, subject to is nothing but what? Where compliance of one depends upon compliance of others. Example also I gave. One example you got to know. Same way you will come across a lot of examples. Right? What was the example I gave? Appointment of section 196 says appointment of managerial person is subject to 197 and schedule 5. Okay, 196 of which act I am talking about? Obviously Companies Act. Correct? That's our favorite. And predominantly we have in our syllabus Companies Act. Obviously when I don't specify something, probably we'll understand it as Companies Act. Okay. So overriding, listen to me. Overriding, listen to me. Subject to, no, I'll listen to you also. You understand? Overriding is like, listen to me. And subject to is like, I'll listen to you. I'll listen to you. Are you getting it? Without prejudice to. Heard of this word prejudice? Prejudicial. What is the opposite of this, by the way? Beneficial. Opposite of prejudicial is what? Beneficial. Now tell me the meaning. Prejudicial. Beneficial is harmless or harmful? Harmless. Beneficial is harmless. So prejudicial is harmful. Harmful is prejudicial. So prejudice, without prejudice to. That means without harming others. Correct? Ahimsa paramo dharam. Understand? Ahimsa, non-violence. Okay, ahimsa. Ahimsa, non-violence. Do you know or not? Without prejudice to, without harming others. So one section might say without prejudice to the other section, the other provisions of this chapter, the other provisions of the act. Getting it? That way. Next. So save, anyways we talked about saving. Now next one, misfeasance. Sir, wherever miss is there, something wrong happens. Yes or no? Hey! Sir, but this is MIS. We are not talking about MISs, madams. Please don't mind. MIS. So misfeasance, misstatement, misrepresentation, miscommunication. Just imagine MIS. Wherever MIS is there, something wrong, no? Mistake. MIS. Not MI-double-S. So please understand misfeasance. That means what is happening here? Something is, sir, maybe not feasible. Something is maybe not feasible, like this noise in the speaker. Isn't it? Not feasible. Yes or no, guys? So misfeasance meaning, can someone tell me? Breach of duty causing loss to others. What? Breach of duty causing loss to others. Oh, so if someone does a breach and that causes loss to others, then it is called as misfeasance. Yes. Sir, we already read this. Yes, that's why I have also asked. Promoters should not be making secret profits in a company. Am I right? But if he does this, then he is doing a breach of duty, and it will cause loss to whom? Company. Others meaning company, stakeholders. Yes or no? That is where suit for misfeasance can be filed against the promoter. What? Suit for misfeasance can be filed against the promoter. I do some mistake. Okay. I do some breach. I don't cover a particular topic. I don't cover a particular amendment, and that comes in the examination. You lose marks. Can you say misfeasance it is? Yes. Simply breach of duty is not misfeasance. Breach of, it should affect someone. It should affect others. Breach of duty causing loss to others. That is where misfeasance. That is where we'll say non-feasible, not feasible for someone. Clear to you? Now connected to this is disgorgement. Next term, disgorgement. Heard of this word, disgorgement? No? Okay. We said the promoter should not make secret profits, but that dirty fellow made secret profits. So do you think company can recover it back? What is it called as? Disgorgement. Or maybe because of that promoter, someone suffered a loss and he is asked to compensate that loss. What is that? Disgorgement. Do you understand what I'm saying? Please understand what we are talking about. Disgorgement means where you recover the wrongful profits earned by a person, or you ask him to compensate that loss which has happened because of him. Either of it. Compensate the loss or refund the wrongful profits which you have earned. Refund the wrongful profits which you have earned. What is misfeasance? Come on, guys. Breach of duty causing loss to others. Right? And then what is disgorgement? I said recovery or refund of wrongful profits which he has earned, right? Or compensating the loss. Correct? So is there any relation between these two? Yes, sir. Sir, misfeasance is the cause and disgorgement is the effect. Okay? Misfeasance is the cause and disgorgement is the effect. Yes. Good afternoon to all the students who are attending live. Very good afternoon. Hello, hi. Please do share your concern in case you have any concern, any doubts, okay, in the chat box. I am keeping an eye over it as well. It goes without saying to you guys who are, come on, seeing me face to face. Any doubts, any concern, what will you do? Ask or not ask? Ask. Raise your hand, let me know. Okay? Chalo. Now let's go for the next one. Forthwith, anyways done. Injunction. Okay? Next one. It's not injection, no? Injunction. What did we say is? Stay. We discussed it, right? Stay. Statue. Don't write in the exam like this, huh? But just for understanding. Okay, stay. That means statue, basically stop. So restraining a person from doing that thing which himself said he will not do. Restraining means what? Stopping. Stopping a person from doing that thing which himself said he will not do. Now some student is creating nuisance in this class. Okay, so I stop him. Can I use the word injunction? Yes. Because the moment he has entered the class, that means he has said that I will not do nuisance, I will rather study. I will not create problem or cause problems. So I can stop him from doing that, no? See, I cannot make him study, but I can stop him from creating nuisance. Like I have given you the example, I think, of whom? Prabhas, Rajamouli, 5 years. Right? Then this fellow starts working for Karan Johar after a year. Whereas he said he will not work, but then he is working. So now Rajamouli Garu can bring an injunction order whereby he can stop Prabhas from acting in or acting with any other production house. Maybe he cannot compel him to work with him, but he can compel him to not work with others. Injunction. Remember, no? Next. 2 we have discussed. Now let's go for convict. All of us know? Yes, sir. A person who's found to be guilty. So once convict, then he will be convicted. Once he is a convict, that means he is declared to be guilty, then he will be punished. Sir, how much will be the penalty? That how can I say? That will law will decide, no? Whether imprisonment should be there, fine should be there, both should be there. And if imprisonment, then how much it should be there? Do you think you and me will decide? No. Judge will decide, that too based on the act, but based on the law. Right? Convict. Person who's found to be guilty. And the verb form, convicted. Now what is acquit? Very easy for you now. What is acquit? Acquittal. Person who's found to be or declared to be innocent. Opposite. Okay, acquit means what? Person who's found to be innocent. Have you not come across these words? In your cmainter you come across. Convict, same way acquit. Convicted, acquitted. Acquitted. So that means he'll not be punished, he'll be released. He'll be asked to go. Okay? No problem. But now pay attention. That's why I'm taking this. The very reason of taking these things is to waste time. No. The idea is to build whatever is required for the subject. We're trying to build that so that we don't face this problem later on at least. Okay? Great. Then let's go for the 13th one. Come on, 13th one. The decree, we know court order, correct? You already are answering. Very good. Decree is court order. Now the question is, when do we use the word held? When do you use the word upheld? Court held that. You might have heard of. The court held. It was held. So held word is used for or used when. Same way upheld is used when. The decision might go in favor of plaintiff or defendant. Suppose the decision goes in favor of plaintiff. Who's plaintiff? Complainant, petitioner. Then upheld word is used. Which word? Upheld. If decision goes in favor of whom? Plaintiff. Okay, sir. Decision in favor of plaintiff. Then we may use the word upheld. And held? Held anyone. So whether the decision is in favor of plaintiff or defendant, held word can be used anytime. You don't have to be careful with. But upheld, you have to be careful. The moment I say Solomon versus Solomon and Company Limited, and then I say court upheld, that means matter went in favor of, the decision was in favor of Solomon, not Solomon and Company Limited. Isn't it, guys? Great. Next, petition, application. Application filed with whom? Principal of the college. Then court, the judicial or quasi-judicial bodies. When you file the suit, when you file the application with court, meaning judicial or quasi-judicial bodies, that is where we call it as petition. And that's where we were saying petitioner. Plaintiff is also called as petitioner. Let's not use the general words like complainant, applicant. Those are general words. Legal words, petitioner, plaintiff. That will be much better, isn't it? So petition, nothing but application. Application filed with court. And as I've told you, if you want to improve, if you want to increase your legal vocabulary, what you should do? Start using in your day-to-day life with those who can understand. Next. So take into cognizance, cognizable offense. We have heard this term again, time and again. Have you not heard this cognizance word, cognizable? You might have for sure. So what do you mean by cognizable? Cognizance. They'll take into cognizance. That means they will admit, but provided some conditions are fulfilled. Provided some conditions are fulfilled. Admit, accept, look into. I will look into your notebook provided you complete it. That means I'm putting a condition. If that condition is satisfied, then only I'm ready to see your book. Then only I'm ready to review your book or your work. You understand? Same way when we are saying, they'll say, we will take into cognizance this case. That means if some conditions which they've stated are fulfilled, then we will look into the case, otherwise not. This is one meaning of cognizance. You understand? Or cognizable. Second meaning, they may arrest a person. If that's a cognizable offense, then they may arrest, they meaning authorities, may arrest a person without even a warrant or court order. Without even a warrant or court order. Somebody killed some other person. One person killed another person. Do you think police will first get order from the court and then arrest him? No. So we can understand as a cognizable offense, which are normally non-bailable also. Non-bailable as well. Cognizable offense is serious. You understand? If someone is involved in cognizable offense, the authorities may arrest him without even warrants or court orders. Clear to you, all of you? So two meanings. First, sir, they may admit or accept the case only when some conditions are fulfilled. Second meaning, arresting a person without a court order or warrant. Okay, so cognizable is dangerous, because if you want the case to be admitted, you need to comply with conditions, and if it comes to arresting, they can arrest without warrant and order also. Now non-cognizable, opposite. So sir, no conditions, and then warrant is required. If they have to arrest the person, without warrant they cannot arrest. You understand? No? So serious cases will be, serious offenses will be cognizable. Now let's go for compoundable or non-compoundable. Okay. Now I hope you are able to understand. But then when you are trying to write, you are facing difficulty. Am I right? Yes or no? So that is where the relevance of writing. If you just listen to me, if you just understand, that won't help. That is 50% job done. Remaining 50% is writing. Because when you start writing, you will be like, how do I write? Which word I should use? How should I frame the sentence? Isn't it? All those things will come. So writing practices. And if you get any doubt, never ask me. Never ask me. Yes or no? No, not at all. You can ask. So if you're facing difficulty, do let me know. I will help you. If you do not, then I'll assume everything is going fine and we'll continue. Okay? Right, sir. So compoundable, non-compoundable offenses. Heard of it? No? What is compoundable offense? When we say fine in lieu of prosecution. In lieu of what? Prosecution. That sort of offense is compoundable offense. Fine instead of prosecution. Now a person, let's say our friend Sundar, jumps the signal, traffic signal. What will the Mamu do? Come on, let's go to court. Let's have the hearing. No, then he'll pay fine and leave. So fine in lieu of prosecution, that means the offense is compoundable. Clear? Whereas non-compoundable, prosecution. Prosecution you'll have to face that music. Isn't it? That music will not be pleasing music, bitter music. So please understand, prosecution is what is going to be done there. So again, if I give you an example, someone kills another person and he says, take fine, I'm ready to pay fine and leave, go. Babu, isn't it? That is what? Non-compoundable. Prosecution only will take place there. You understand what I'm saying? Prosecution, filing suit, court proceedings, and fine is obviously fine. Paying fine in lieu of prosecution. So non-compoundable becomes really dangerous because their prosecution only. Cognizable is dangerous. Ulta. Cognizable and here non-compoundable. Don't think compoundable is dangerous. But both are not good. But relatively I'm saying, if I compare with this, okay, non-compoundable is dangerous. Cognizable is dangerous. Clear? Achha, how will we identify that a particular offense is compoundable or non-compoundable? Any idea? Any idea? Come on, my dear friends. Any idea? An idea can change your life. Anna? No? See, when you read some provision and you find that the offense leads to fine only, or fine or imprisonment, fine or imprisonment. So you pay fine and leave. That possibility is there. Fine or imprisonment or both. Again, possibility of paying fine and leaving is there. Yes or no? But if I talk about imprisonment only, Come on, guys, answer. Non-compoundable. There's no question of paying fine and leaving. Next, fine and imprisonment. Again, non-compoundable. So these are non-compoundable offenses, and the right hand side, fine only, fine or imprisonment or both are compoundable offense. You understand? All of you? Sure? Right? Fine only, fine or imprisonment or both. This helps us understand that offense is compoundable. Otherwise, we'll say non-compoundable. So when it is non-compoundable, prosecution. Paying fine and leaving is not possible. So next time we come across this word, I hope you will answer. Anna, camera, you will answer, no beta? Light? Good, at least you're there. Please, I'm asking you, no, please answer, please reply. Next one, I bid. Heard of I bid? Comes from the Latin word I bidem. Comes from the Latin word I bidem. Heard of it? Yes, sir, we don't hear all this. Don't waste time. Do you know what is this sign? Hey, what is this sign, boss? Ditto marks. Same as above. You use no? Yes, sir, we do use. I bid. I bid. I bidem. So in barracks, when you read, you will find they'll say I bid. That means they're saying whatever written above will apply here also. Ditto marks. Comes from the Latin word I bidem. I'll show you the bare act again. You'll find that. So don't be blank when you come across this next time. Okay? Bona fide, mala fide, anyways, is clear to you. Bona fide means, the bona fide certificate in schools are so good or bad? Good, no. Mala fide means bad. With negative intentions, wrong intentions, then mala fide. His conduct is mala fide. His conduct is bona fide. So when it is mala fide, they'll never issue bona fide certificate. They'll issue bona fide certificate only when there is some bona fide conduct. Correct? Good. Next, ipso facto. No? No one? By the mere fact of it. What? By the mere fact of it. By the mere fact of it. What does this mean? Sir, ipso facto, we sit in the class doesn't mean we are attending the class. Am I right? By the mere fact that you're sitting in the class, does it mean you're attending the class? No. Why? Because physically present, mentally you might be absent. So same way, in law also you may come across ipso facto. So by the mere fact of doing this doesn't imply you are innocent. Clear? Ipso facto. Facto, fact, by the mere fact of it. Okay. Next one. Modus operandi. So this we have heard lot of times. Not just law students or law subject, but we'll use it outside as well. Modus operandi. Very, very good. Who said this? Good. Perfect. Mode of operation. Correct? Mode of operation. Now, if someone asks the modus operandi of your classes, that means they are asking mode of operating the classes. You understand? Everyone will have some modus operandi, no? Every business, every company, every person. Come on, how do you operate? That means they are asking you modus operandi. They will use the word modus operandi, so you should know that's nothing but mode of operating, operations. Right, sir. Next, de jure, de facto. No? Facto, again fact. So, by fact. And you say by law. By law, that becomes de jure. Or by right. When someone says by right, by law is same. De jure. Okay, and de facto, by fact. So I'm saying this, and that is coming from law. So I can use the word de jure. That means it's because of law, by law, I'm getting this point. No, from some fact. De facto. Mutatis mutandis. Suppose I say chartered accountant's definition and cost accountant definition in company law. Suppose I take the example of that. I hope you are aware that cost accountant's definition is mutatis mutandis to the definition of chartered accountant. Suitable modification. Not same, we'll say suitable modification. What's the definition, by the way? Chartered accountant defined under Companies Act as, how will we remember? Did you read at least? Okay, no problem. Chartered accountant means one who's defined under CA Act, Chartered Accountants Act 1949, and holds valid certificate of practice. Okay, chartered accountant means a chartered accountant as defined under CA Act and holds valid certificate of practice. That's the definition given. Now what about cost accountant? Mutatis mutandis. So what will you do? Instead of chartered accountant, you will say cost accountant as defined under CWA Act and holds valid certificate of practice. Oh, so CA you have replaced with cost accountant, CA Act you have replaced with CWA Act. So suitable modification you have done. You got the answer for cost accountant as well. Yes or no, guys? Yes. So good. Subramanian. But you have to say suitable modification. Here, so we'll not say same, but we'll say same. However, some suitable modification has to be made. So we do this quite a number of times. Okay, let me take one more example. Articles defined under 2 clause 5. Company law, articles 2 clause 5 as what? Articles means articles of association as originally framed or altered from time to time in portions of this act. Okay. Now give me the definition of memorandum, which is given under 2 clause 56. Memorandum means memorandum of association as originally framed or altered from time to time in portions of the Companies Act. So what did I change? Just one word. Articles I've changed with or replaced with memorandum. That's it. Got the definition. So memorandum's definition is mutatis mutandis to articles definition. So once you read 2 clause 5, that means in a way you have read 2 clause 56 also. Shall I start with directors? You understood, no? So let us come to a level where we should not be blank. We are not blank. If you are blank in these type of things, it will be hurting us a lot later on. Okay, so that is where you might have got the answer also when I said on day 1 that I'll be requiring minimum, or not minimum, sorry, around 150 hours. So if you want to understand, rather those who are attending properly the classes have understood already why I'll take more time than other teachers. Normally people say 100 hours, 120 hours is enough, but I'm taking more number of hours. Reason? We want to finish the subject, correct? No, we want to complete the subject. We want to understand it properly so that any surprises comes in the exam, we are ready. Any surprises come in the profession, we are ready. At least to some extent you should be ready, if not fully, isn't it? So that's where we are calling it as regular batch as well. Okay. So this was some discussion or some brief discussion on basics of law, basics of interpretation with even some legal terms. Now we can go for Companies Act, correct? But before that, let me just show you the glossary once so that you can know how you have to maintain your book as well. Okay. You have your notebook in front of you? Yes, sir. So maybe you can divide it into 2 halves. First half, if it is a 200 pages notebook, maybe 150 pages first half, 50 pages second half. It's not 100 equal, okay? In the second half, 50 pages, you can prepare glossary, wherein you will write all important things at one place. Like you could just read one by one. Important sections. Yes, sir. All important sections I want to list down. Next, Latin maxims, litra legis, ratio legis, ignorantia juris non exequisat. Already we discussed these 3. Caveatemptor. Caveatemptor. Let the buyer beware. Like that we are coming across, no? Latin maxims. Yes, sir. Now also you said I bid him. So please understand, we can write those at one place. It will be helpful. Next, important consequences or penalties. Sir, penalty and consequence, is there a difference? Yes. Contract becomes void. Consequence, no? Person has to pay fine of 1 lakh. Penalty, no? So we understand there's a difference. So sometimes there will be consequences, sometimes there will be, or sometimes both also. So we can, at least important ones, we can make a list. Then legal dictionary. I don't have to tell you why it is required, isn't it? Are you able to see, or I should zoom in? Is this fine? List of prescribed companies. Like women director, is it required for every company? Audit committee, is it required for every company? Independent directors, required for every company? Cost audit, required for every company? You know, prescribed companies only they need. So which are those companies where we require? So we'll make a list of those cases where we have prescribed companies word. Okay. Then approval of members. Approval of members, shareholders, sometimes ordinary resolution, sometimes special resolution. Sometimes 90% of members need to give approval. Like that, we may come across approval of members wherein we may have OR, SR or others. Correct? Next, important case laws. Important time limits. Time limits. Next, important limits. Yes, sir. When we talk about subsidiary company, we say more than half. And when we talk about government company, we say 51% or more than 51%. Subsidiary, we are saying more than half, meaning more than 50. But for government company, 51 or more than 51. So difference there, no? Like that, you may come across some limits, not just percentages, even amounts. So we'll write that as well. Okay. Next, overriding provisions. Yes, sir. Just now we discussed overriding means enjoy supremacy. So overriding what also matters. Next, tell me, whom should you listen to? Father or brother? Father or brother? Okay, Sridhar. Glad. Thank you. Sir, as such, we don't listen to anyone. But at least for namesake, you have to say something. So you will say father. Am I right? But if father says listen to brother, listen to Anna, then you have to listen. Father says listen to Akka, then you have to listen to Akka. Right? Elder sister. Same way, in Companies Act, tell me, Companies Act and articles. Whose father, whose Akka or Anna? So obviously Companies Act is father and articles is Anna or Akka. Yes or no? So you should listen to, you should follow what is written in the Act. But Act itself says, if specified in articles, if authorized by articles, then what do? You have no option. Only if articles permit, then you can do, otherwise not. So that is what is overriding effect of AOA. Understand? Oh my God. So specific authorization of AOA. So where is it written? Because in your syllabus we'll come across this. So we need to prepare a list later on. Just understand, one day before examination when you're revising the subject, do you think in principle you will know the provisions, the laws? Yes, sir. But you will be stuck with these type of things. I forgot that penalty. I forgot where OR required, SR required, where they are saying AOA authorization is must. What was that limit? What was that? Come on, Latin word used there. Don't you think these are the things which will confuse you or probably lower your confidence? But if all of that is at one place, what will happen? Yes. Confidence will go up. No. That's why we are preparing for that last day. Okay. Next, you will find a lot of registers in company law. Yes, sir. Register of company, register of charges, register of debentures, like that. N number of registers are there. And some registers they say inspection will allow. Some registers they say copy you can take, extract you can take. And who will be allowed to inspect, who will be allowed to take copy. There are some fees also they charge sometimes. Correct? We can prepare a list. Next, important date. Correct? Sometimes important date. If not, we'll ignore it. Then some sections cover 447 penalty. What is 447 penalty? Penalty for fraud, not general penalty. It's penalty for fraud. Only when section says, then only it comes, otherwise not. Whereas general penalty means not that, still it may come. How and why, I'll tell you. Wait. Okay, wait for that. Next, some provisions are not applicable to private company. Some provisions are not applicable to public company. Some provisions are exempt for government company. Some provisions are exempt for section 8 company, Nidhi company, private company. Like that we have no list. If you just see this point 17 and 18, provisions not applicable, provisions exempt. You understand the difference between non-applicability and exemption? Yes sir, very much. Now the do's and don'ts. The do's and don'ts of our classes are applicable to you guys. But I say, Pawan, if you don't follow, it's okay. What does that mean? Exemption. What about the students at the other floors? Not applicable only. So we know this, right? So not applicable, exemptions both. Then English dictionary, because at least some level of English you should have. You cannot write the way you speak. I've told you on day 1 itself. Then do's and don'ts for presentation. Yes sir, just now you were talking about held, upheld. Anna? Then few more important points you can write. See, normally when NCLT gives some decision and you're not happy with it, can you appeal further? You'll say yes sir. We can move to NCLAT. Still not happy, then Supreme Court. But sometimes when they say decision of NCLT is final, that means you cannot appeal further. Sometimes they may say decision of NCLAT is final, you cannot proceed further. So those type of things are important or not important? They're very important. We'll make a list of that. Sometimes you will come across the word PFI, sometimes FI instead of bank. So we have to be clear. Sometimes body corporate, not simply company. Sometimes not just shares, securities. In private company, public invitation for securities is prohibited. Yes or no? Or shall I say only shares? Public issue of shares is prohibited. They can come up with public issue of debentures. No sir. Securities. You're getting it? Securities is wider. Body corporate is wider. We need to understand. So where are they using this? Same way, which sections have given the power, or where is it said that ROC has the power to strike off the name of the company? That means declare defunct. Where is it written? So there are many sections where we find. Write at one place so that you will not say many. There are only 8 to 10 you will find in your syllabus. Then sections covering public interest. Some sections will say public interest. Like in CA final, one time a question was asked, what is public interest? And give examples of those provisions which contains the word public interest. Students were like, what nonsense? No nonsense. This is how they'll test your concepts. So direct question also can become difficult, provided you don't pay attention. By the way, what is public interest? Now guys, suppose I say lakhs of shareholders are affected. Can I say public interest got affected? Yes or no? The answer is no. Please understand, in company, we might have shareholders, correct? We might have shareholders. Good, Subramaniam. Sorry, I saw it late. There are also financial creditors. There are employees. There are workers. There are board of directors. Come on guys, answer. Yes or no? Yes sir. Plus there are customers. Because we said responsibility has moved from shareholders to stakeholders. Stake means what? Interest. Stakeholder, interested party. Correct? No? We're talking about corporate governance. Governing the corporate in the best possible manner. Meaning the objective should be achieved. So what is the objective? To take care of all the stakeholders. So please understand, when I'm talking about company, you'll find shareholders, you'll find financial creditors like your debenture holders, bankers and all who give loan. Then your employees, workers, board of directors, customers. You'll say, sir, suppliers. That means trade creditors also. Correct? Sir, competitors are also there, sir. Next, sir, government is there. How can we forget? Society is there. Like that, don't you think various stakeholders are there? Don't you think various sections of public is involved here? So when we say all the sections of public got affected, all the sections, that means public interest got affected. Or all the sections of public is involved, interest is involved, that means public interest is involved. Or if not all, majority. If not all, majority. You say only shareholders got affected, lakhs of shareholders got affected. So what? Ultimately it affected only shareholders. You cannot say public. You say, sir, customers, lakhs of customers, thousands of customers got affected. Ultimately only customers got affected. Clear? Suppose students only got affected. It's only students. I cannot say public, maybe thousands, lakhs, but it is students then. But you say, no, not just students, teachers also got affected, right? Institutions also got affected, management got affected, parents got affected. Like that, when you start saying, that means public interest got affected. So you have to be careful when you come across the word public interest. Okay, that becomes important for us. So that is where even this can make a note. So like this, in your notebook, if you write these things properly, it will help you a lot. So you can take pic of this, okay, then you can zoom in, right? Take a pic, first zoom it and take pic, then further zoom it, or if not, first try, if not then we'll see. Or someone can come in front and take it and then share with your friends. No? Shweta, is it helping or no? Helping, no? You can read. No? Okay, no problem. I will share it. Okay, I'll share this PDF. Whatever group you have, do that. So you can prepare the format. I have not just given the list. If you see, I have given the format also. In that format you prepare, it will be helpful. Because you just write but not write properly, again it is of no use. Acha, sir, you have given some 22 items. So is it only 22 which we should prepare? Not at all. This is the idea which I am giving. You can build on this idea. You can improvise. If you think 25 items, you think more items, please include. No one is stopping you. Clear? This is for you, not for me, not for your friend. This is for yourself. So whatever you want to prepare, what you think can help you, go ahead with it. Okay? And initially, 5 days, 7 days, you will face lot of difficulty preparing this, is what students say. I don't say that, because no one told me this. I used to prepare. No one guided, no one gave the clue. I only thought I should prepare it. So when I was a student, I used to prepare like this. It helped me a lot. So I passed on, or I am passing on this to my students as well. Those who prepare, they say it's good, sir. It's very good, sir. It helped me a lot. And those who do not prepare, give me the excuse, sir, very difficult to prepare, sir. How do we prepare, sir? No one can help. I can just say, God bless you. So try, even if it is difficult, it will be difficult for 5-7 days, not more than that. And anyways, if you're facing trouble, I am not there. Yes or no? No, sir, I am there, right? You are there. So then why get scared? You try. Try. Till we succeed. I'm not saying you succeed. Okay. Then, can you see something here? Some useful links. If you like it, you can use it. Yes or no? No. Even if you don't like it, you have to use it. It's not about your liking, my liking. It's about the subject. So mca.gov.in. Are you aware of this? Yes, sir. MCA website. ca2013.com. Chartered Accountant 2013. No. Companies Act 2013. Okay. Same way, indiacode.nic.in. mcacdm.nic.in. E-Gazette. E-Gazette. Haan, sir. Official Gazette. You were saying some website. Yes. Then igod, that is government department. So igod.gov.in. We have these type of websites which can be useful at least for company law, and to some extent, like this one you can use it for any law, this one you can use it for any law, but of course this one company law, right? Company law. The one in circle. Oh, 1 minute. This one again, any. Okay. So show us no. And you have written there, or you have mentioned even FEMA. That anyways, when we start FEMA, that time I'll tell you. Not required now. Okay. What could you see here? India code. Anna? Who? What happened? Work issue. There is full Wi-Fi here. Okay. See, this is the website ca2013.com. Can you see on the screen? Top center, ca2013. Right. In this, if you just see, what do we have? Companies Act. Act, rules, schedules. IBC, rules, regulations. Right. SEBI related also we have something. You want to refer to some foreign company law? United Kingdom's Companies Act 2006. Irish, Sri Lanka, Singapore. So this sorry, this particular website, which was useful earlier only for Companies Act, now is extended to even IBC and SEBI. SEBI not completely though, but still useful. So now you just see there are chapters. How many chapters are there in Companies Act? 1 to 29. Here 1, 2, 3, 4 like that. It goes on till how much? 29. How many sections are there? 1 to 470. Sir, why are you saying 1 to 470? You can simply say 470. I will not say much. You will only answer. What is this chapter? 21A. Section number 378A to 370Z. Z. Further, it is there. I'll show you. It's not Z. It doesn't stop at Z. ZA, ZB also you'll find. See. ZU. So can I tell you that there are only 470 sections? No, it is wrong if I say 470. Remember one golden rule in life. If you can't be right, don't be wrong. If you can't be specific, accurate, then don't be wrong again. Understand? So if I say 1 to 470, maybe I'm not accurate, I'm not correct, but am I wrong? No. But if I say 470, I'm wrong. Same way I say 7 schedules, maybe correct today, correct, because no deletion addition, but in future if it changes, they bring in schedule 3A, schedule 3B, then so better to say 1 to 7 schedules, 1 to 29 chapters, 1 to 470 sections. You understand? All of you? How many rules are there? Any idea? Idea can change your life. See here, rules. Oh. Full jaws. Chapter 1. Come on, guys. 2 set of rules. Chapter 2, 1 set of rules. Chapter 3, 4. I'll show you chapter 9. Okay. See, chapter 9. 1, 2, 3, 4, 5, 6, 7, 8, 9, and 10. 10 set of rules for chapter number 9, accounts. Getting it? So that is where I cannot say 29 set of rules. I have to say every chapter has got one set of rules, but there are exceptions where more number of or more set of rules are also there. So are we required to read these rules as well? Yes, sir. We read the objective. We already know syllabus. We have discussed. They're saying important rules you have to study. You can't ignore rules and study this Companies Act. Same way, IBC, you cannot ignore regulations or rules and read IBC. That's not possible. Like Income Tax Act rules, you have to read rules. No, here also rules are there. But luckily, you don't have every rule in your syllabus. Important ones you have to cover. Okay, fine. Right, sir. So this ca2013.com you have seen once. We'll be using it for Companies Act. Okay, IBC, SEBI. Now let's see whether India code is working. Oh. Maybe something wrong with the website. This is anyways MCA's website. Right, who's this person? This gentleman? Mr. Harsh Malhotra, who's the deputy. Like you have captain, vice captain. Same way here. Okay, Nirmala ji is supported by Harsh Malhotra ji. Sir, he is the Honorable Minister of State, they mentioned. Meaning, if you see, cabinet rank, Nirmala ji occupies. And state rank, Harsh Malhotra ji. These are ranking. So superior will have cabinet rank and junior will have state rank. State rank doesn't mean particular state. I hope you know India is also state. In the context you need to understand. Don't think only country means India or India means country. India can be even called as a state. It all depends. Generally we avoid that and we use the word country. Anyways, so this is MCA's website. We'll refer when we require. But you should have an idea. That's why I'm just sharing with you. So that's where this dabba can be useful. You understand? We probably think this dabba is an idiot box, like our TV box. No, TV box is an idiot box, but this one is going to help us a lot. Okay. Camera lights, AC. Oh, so your names are camera lights, AC, is it? Because when I say that, then only you respond. Hope that's not the case, huh? Same way, e-gazette and all, when we require, we'll see that. Okay. So these websites can help you. I wanted India code at least to be shown, but tomorrow, or we'll try again later. Now let's go for. So now you'll take a fresh page, basics of law and interpretation done. Right, fresh page, you will write company law. Starting with company law, in that we are talking about first basics and overview. Basics and overview. Let's understand few basics of company law and let's take the overview of it. Sir, already given the overview, no sir? You said 1 to 29 chapters, 1 to 470 sections, 1 to 7 schedules. Yes, but slightly in detail. Okay, we'll talk about it and you may note it as well. I hope my live students, YouTube live students are able to follow as well. No response. Yeah, great. Few thanks for those who are responding. Yeah. So now, as we said, let's talk about some basics and overview of Companies Act. What is the objective with which they are asking you to study company law? Expert knowledge. We've seen the objective CMA Institute has kept for company law. So when can you call yourself as an expert? When you ignore basics, when you ignore miscellaneous provisions. Those are utmost important things. That will only make you an expert. Don't know these fundamental things and you're calling yourself as an expert, you'll be in an embarrassing situation. That's why we are talking about. Achha, is there any relevance of these pictures here? Or simply I like it, that's why I pasted it? Definitely there is some reason behind it. Please understand. Okay. Like when I say here, or when I take this picture, I understand, okay, law is organized properly. Law is organized step by step. Law has to be read step by step. Next thing, Companies Act is not implemented at one go. Few provisions first and then few provisions later. In parts it was implemented or not? Phases it was implemented or not? Yes, sir. That also it signifies. Then I hope you know the meaning of this word construction. Construction. You know the meaning of this word? Do you know what is reasonable interpretation? Come on, we discussed no going beyond the words. Reading between the lines, between the words. That is construction. So, sir, reasonable interpretation itself is construction. Yes. So, you will even find the word, rather you might have come across this word construed. Have you come across? While reading law, you will come across this word. Construed means interpreted, understood. Comes from the word construction. So, construction means not that construction of building we are talking about here. We are talking about construction of law. So, if someone says construction of law, don't be surprised, don't laugh. It means basically he's saying reasonable interpretation we are doing. Okay? We are going beyond the words. We are going to talk about the rational, the circumstances here. So that is where this picture. So there is some reason for every picture, not that just pasted. Okay? Right, sir. Now, the first thing there, history. Now, currently, which particular Companies Act we have? 2013. Before that, yes, that is where we are talking about. Because what's the definition of company? Company means a company incorporated, registered under this Companies Act or any of the previous Companies Act. So we should know the previous company law, right? So that is where we are talking about it. So the heading which you will give is history. You have written the broad heading company law. In that you have written basics and overview of company law. That is over. Now concept. One by one we are discussing concept. The first concept which we have is history. Right. So it all started with which year, which act? For your kind information, 1850. Then 1866, then 1882, then 1913, then 1956, then 2013. Yes, correct. So this is how this act evolved. Okay. So shall we write again and again fully? No need, boss. You just write the year. First you write history, the Companies Act, and next time 1850, 1866, just write the years. Enough. And don't waste space. Don't waste pages. Write horizontally. Enough, no. I wanted to beautify. That's why vertically I've written like that. Think of saving pages also. It's your parents' hard-earned money. Don't waste it unless it is required to be wasted. Like marriage, you will have to waste. You will be wasting, isn't it? Though we know it is wastage, but still we waste. Everyone wastes. I mean, I'm not saying marriage is waste. I'm saying expenditure incurred to show off people and all. Shall we go to the next one? Why? You're in a hurry. No, no. Then at least let's take one or two questions here. Then we'll go to the next one. Sir, what is the life of Companies Act 1956? 57 plus years. Am I right? I'll use white only. White is better, I guess. 57 plus years. Life of Companies Act 1956. Arey boss, 2013. So 57 is the difference. And why I'm saying plus? Sir, because we know 2013 was not implemented at one go. So it was only in the year 2019 actually, this 1956 completely, come on guys, we got it away from, and we have this new law. Okay. Same way, now what is the life of 1850? 16 plus. 66, 16 plus. Then 31 plus. Then 43 plus. And then comes 57 plus. So what do you observe here? Analytics, analysis. All of us know. What do you notice here? The life of Companies Act is improving. Earlier when they made Companies Act, it could sustain only for 16 plus years. Second also 16 plus year, but then they improved it, 31 plus. Then they further improved it, 43 plus. Then they further improved it. So what do you expect from Companies Act 2013? How much time do you think this will remain in force? Sir, probably 75, 80 years, 100 years, who knows? But we expect something more only now. Our expectations are more now. And is it possible? The answer is yes. How? I'll tell you. Because this act is not just act, but read with rules. So when it is read with rules, very smartly what they've done is, anything which requires change frequently, that is kept in rules. So act will not change or will not require amendments frequently. What will require changes frequently? Rules. So act life will go up. So that is why people call company law as rule embedded law. Rule embedded law. Clear? Next. Anything else you notice? Anything else you notice? Important one. Don't give me, sir, Indian is written there, company there. That's okay. Yaar. Don't bother about that. Next thing, if you notice, the pattern of the name or the title. The Companies Act 1850. So 4 elements are there in the title. Then the name, then act, then year. The name, act, year. The name, act, year. Any law you take. The Income Tax Act 2025. The name, act, sometimes instead of act, code. Correct? So we understand the pattern. The pattern is uniform. The word indicates uniqueness. Can I say the Sachin Tendulkar? Yes, boss. That's why we call him as God of cricket. He is unique. No one like him. Understand what I'm saying? Come on. The Mahatma Gandhi. Yes, sir. That's why father of the nation. Please understand. When we talk about law as well, the Companies Act, do we have 3 Companies Act in place? We can pick whichever we want. No. So this is the only one. And we have to follow. That's it. So this becomes unique. There can't be 2 Companies Act, 3 Companies Act, 4 Companies Act. Only one. And this is the one. That's why the. Okay, sir. You understood. Fine, no? Acha. This year stands for? 2013 stands for? 1956 stands for? Generally the enforcement year. Generally I'm saying. But sometimes, no. Sometimes enactment year. So maybe enactment year. Enactment means making. Enforcement meaning implementation. So sometimes making, year of making, sometimes year of implementation. Generally, exceptions can be there, but generally this is the case. Okay, now let's proceed. If you want, I can spend 10 more minutes on this, but I will not waste your time. Let's go to the next one. Why this Companies Act 2013? Okay, so one of your friend is asking a question, Mr. Naveen. He's saying, sir, as you said in the definition, like Companies Act and other previous Companies Act, in new act, we will be having the old act, right? Then why we need to refer them, sir? Okay, maybe he's trying to say that, why are we talking about old act? See guys, if I talk about a company like Reliance Industries Limited, if I talk about a company like Infosys Technologies Limited, like that, there are many companies. They were registered under Companies Act 1956. Some companies are there which were registered under 1913 also. Isn't it? Yeah, Tata group of companies are pretty old. So we know that they were registered under those acts. but today also those companies exist. So is it that they will follow those acts under which they are registered? No. They will follow the act which is in force now. That is where they wrote in section 1 also, this Companies Act 2013 applies to not just the companies registered under this act, but also under previous company law. That's why section 1 also we have to see, and we will cover that. See here, section 1. I'm going to cover that. Okay, so just hold on for section 1. But I hope you have understood what I'm trying to tell you. So maybe registered under previous Companies Act, but still it will be coming under the purview, and they'll also have to follow Companies Act. Clear? Naveen, if any other doubt you have, please message or please let me know. Otherwise, I'll assume this is what you were asking. Now coming to why Companies Act 2013? When already 1956 was there, what was the need for 2013? Very good, sir. Changes. Law is for society, we said. Society is changing or not? Okay, Naveen, thank you. The law is for society. Society is evolving, society is changing. Law also has to change. And that too, not just one or two changes. Many, multiple, huge. So they got a new law. But if someone asks, you cannot just say huge changes were required because huge change happened in the liking and disliking of people, isn't it? You'll have to give some professional answer. If someone asks why Companies Act 2013, then what will you say? Sir, first thing, simplify. 1956 was becoming too much complicated, so they wanted to simplify. That's why 2013 Act. Sir, corporate governance was there earlier, but maybe not as much required. So 2013 Act, audit committee, independent directors, NRC, SRC, like that. There are many concepts of corporate governance which has been introduced in 2013, unlike 1956. Then independent auditor. That is why they brought or they came up with the concept of rotation. Rotation, not for all companies, but for bigger companies, we need auditor by rotation, no? Can an auditor joins now and be there as an auditor for years and years? No, sir. So we have this concept which was missing. Sir, they wanted even sole proprietors, small businesses to come under company form. That means they wanted to bring the concept of OPC, small companies, dormant companies. If you're dormant, inactive, then also you should continue in company form. So we wanted that as well. That is where Companies Act 2013, right? So you should give these type of corporate social responsibility. How can I forget? The responsibility moved from shareholders to stakeholders. So things like this were needed. That is why they got the new Companies Act, that is 2013 Act. Right, first one, what did we say? Improve. Or first one, what did I write? Improve corporate governance. That was their idea. I know I'm handsome, okay? And you know you're handsome as well. You're beautiful as well. If you don't know, then I'm telling you, you are beautiful, you are handsome too. You don't think you're beautiful or handsome, don't expect others to say that. And it's not just about external beauty, external appearance we're talking about. We're talking about within as well. We're talking about your intelligence as well. You guys are smart. You are good. You are champions. You are our future. You are our nation builders. Please understand this. All of you, you never know who. Someone might become finance minister of this country. Someone will become the commerce and industry minister. You never know, boss. So don't underestimate yourself. Don't underestimate your friends. Don't underestimate yourself, please. Okay. So improve corporate governance. CSR, yes sir. One person company, rotation of auditors. Even we wanted a separate SFIO. Earlier there was a general SFIO, but then they said no. In company law we want separate SFIO, so we want to establish that. You know the full form? You know what it stands for? Serious Fraud Investigation Office. Serious Fraud Investigation Office. Can you guess where will we read this? Can you guess when will we read this? Where will we read this SFIO? Sir, obviously you said Serious Fraud Investigation. So investigation chapter, I, inspection, inquiry, investigation. Try to think, you'll get the answer. See, you may not have the answers, but you should know how to get the answers, from where to get the answers. That's where you'll become a good professional. And that's where networking becomes important. That's where research becomes important. You think client comes to you, ask some question, you'll know the answer for every question? You'll not know. But you should know where to and how to find it. Some client comes and says, which are the best 10 companies to invest in today, as of today? Now you don't know the answer. What will you do? 1 minute. Sorry, sir. Don't mind. I need to take this call. So if you don't mind, please wait outside for 5 minutes. I'll call you once I finish this call. Okay, I'll call you once I finish this phone call. Okay. Okay. So he goes out. Then what do? Yes, sir. Please come. Yeah, I'll call you. Right. Thank you. Sir. What were you saying? 10 investment. But within those 5 minutes, you should know what to refer, where to refer. No. Don't know what to refer, where to refer, then it's going to be difficult. You also know AI. And if AI is incorrect, you have to even validate the data, validate the information which is provided by AI. So you need to know the source, you need to check the source. Correct or not, guys? Can you simply give the source as AI? Client will go to AI only then. Will not come to you. Then you will crib, array, my job has gone. Yes. AI is your friend. AI is your assistant. Use it properly, then you'll rule. That's like Aladdin ka chirag, magic wand which has come to your life. Use it properly, you'll rule like anything. Isn't it? Anyways, hello. So, think serious fraud investigation office, that means inspection, inquiry, investigation. Right, sir. Constitution of NFRA, National Financial Reporting Authority. Accounting standards, auditing standards. Who will see the quality is good? For professionals are working really good. They are providing qualitative service to the clients. NFRA, no? Who's my boss? Sir, you are a chartered accountant, so icai. Who's my super boss? NFRA. Right? They'll oversee the quality of service which I provide to my clients. Here, so we wanted to bring this. That's why 2013. Next, class action suit. Heard of it? Yes, sir. Deposits chapter, when we read in cmainter, we have read this. Sir, please, you don't answer, sir. We'll feel bad. We'll feel insulted. Okay. How can I insult you? Please answer. No? Straight away giving up? No trying? Okay, no problem. Suit for some action. That too, by whom suit? By whom? Some class of members, class of depositors. I'll give you a simple example. You are a member, you are a member, you are a member, you are a member, you are a member of company, of course. You are a member. Now, company's director or management did something wrong. All the members got affected. And if I ask, how did you get affected? How did you get affected? How did you get affected? And I find the answer is same. My friend, at last, I cannot see you. Maybe we can come in front, no, sit beside Pawan. Not visible only. So, let's say all of you, who are the members of the company, got affected. Got affected. And got affected the same way. So, you want to file a suit against whom? The management, the company. Come on, guys. For what? Some remedy, some relief. Correct? And since all of you got affected same way, when you file the suit, you want the same action or not? Yes. So Pawan files, our dear friends file. Okay, like that each one of you file. How many times court will have to hear and take up the case? Sir, if 100 have filed, 100 times. 1000 have filed, 1000 times. So there is a concept of consolidating this. You file, the NCLT will consolidate and take it as one single case. because you guys are the same level of members, same type of member. You are affected the same way. You want the action also same way. Against whom? That is also same person. Why to take 50 times, 100 times, 1000 times this case? One time. So they will treat it as class. They'll not treat it as single member. They'll take it as class. Class action suit. So suit filed for some action by particular class of members. And same way now, instead of members, you're a depositor, you're a depositor, you're a depositor, you're a depositor, you're a depositor. Again, you're affected the same way. You want same action. You may file separately, but they'll consolidate into one class action suit. So you have read this in your deposits chapter earlier. Now you're going to read it again in deposits chapter, no doubt, plus, can you guess, plus which chapter you will find this? Someone was already answering. Someone was answering. Now be louder. And don't be scared. At the most, what will happen? You will go wrong. Am I carrying a stick here? Will I beat you? No. Don't be wrong. No problem. Commit mistakes here. Don't commit in exams. Come on. Where do you think? Which chapter do you think we'll find this class action suit? No, but well tried. Good. Depositors. I've told you deposit chapter. That you got to know. Nothing from members' point of view. Huh? No. Prevention of oppression and mismanagement. Oppression. So they might be affected in the same way. Correct? We'll find it. So we'll study that. Okay, sir. So that is why we wanted this thought. 1956, we didn't have these type of concepts. NCLT, NCLAT special codes. Someone will say, sir, earlier CLB was there, company law board. Now NCLT is there. So there's change in name. Oh, there's a lot of changes. NCLT is a much powerful and strong body compared to CLB. Earlier, when the matter went to CLB and the decision was given and someone was not happy, they used to go to, any idea? High Court. Still not, then Supreme Court. Now, NCLT, NCLAT, then Supreme Court. So, sir, that means instead of High Court, they're saying go to NCLAT. High Court was judicial body. So, used to take up which matters? Any matter. Matter of any law. Correct or not? What about NCLAT? Quasi-judicial body. Will take up which matters? Company law matters. So, quality of judgment will be better. Good. Time of disposing, time for disposal of the case, less, because they're only focusing on this area. Whereas High Court, quality of judgment might not be that great. Time taken will be more. If judgment is good, quality is good, but then time will be more. Now, understand? So they wanted that. That's why they got Companies Act 2000 here. And I hope you know there is a concept of benches also. Meaning, judges doesn't mean only one judge. Sometimes 3-member bench, sometimes 5-member bench, like that you'll hear. That means it's not one judge, 2, 3, like that, depending on the case, of course. So that concept also was brought in here. Okay, so beautiful law, Companies Act 2013 when compared with 1956. When I did my CA, those days we had 1956. So I read that, then this came. So in a way I got to know both, and I can appreciate more because I know the previous law. Like you will also appreciate Income Tax Act 2025. If you know Income Tax Act 1961. Don't know that, then how will you appreciate? Okay, sir. Then simplifying regulations, that is also the idea. Strengthening investors' interest, that is also the idea behind Companies Act 2013. Then etc. What does etc. means? This is an inclusive list. Means we can write more points, but these are major points. So if someone asks you this question, don't say I don't know, or don't give general answer of They want to improvise. Society is changing. So they had to change the law. That is a very general and layman's answer, which will not be accepted. Please, you have to give this. Okay? Come on, guys, answer. Why OPC and small companies? Sir, smaller businesses also in company form. Why company form? Sir, company form is a professional form of business. There are regulations for every single item, single matter. So is it good if we have regulations? Good or bad? Sir, the other day you asked someone to spit a chewing gum and not to have next time. That someone will say, no, you didn't ask to spit. You just said next time you don't have. Okay? Yes or no, guys? I didn't tell you earlier, that's why I told that day. Same way, few things I might not have informed earlier. Now if I inform you, what can happen? You may feel bad. Correct or not? But a few things which I've already informed, will you feel bad for it? No. Okay, sir gave clarity. These are the things which are allowed. These are the things which are not allowed. You have made up your mind. Something new crop up, you'll be like, what nonsense is this? Isn't it? So that is how the relevance. See, if we want to have smooth relation, then don't you think we should have our do's and don'ts clear? Even when tomorrow you get married, you'll have do's and don'ts. Wife will say, even if it's your mistake, you should say sorry. I will not say sorry. You have to accept it. Personal experience, I'm telling you. Okay. It will happen with you also. You're laughing now. Later on, I'll laugh at you. Hello. Anyways, the point is simple. Rules, regulations helps us in having smooth relation. Okay, sir. Now next, let's compare 1956 with 2013 with respect to 2-3 things, not more. Like first of all, the scope. Okay, just see first the scope. What is written there? What is written there in the scope? Sir, part 1 to 13 covering okay. Too much, no? Too much of user friendliness also is dangerous. Anyways, let me do this. Part 1 to 13 covering sections 1 to 658. 1 to 15. Okay. Now, chapters 1 to 29, section 1 to 470, schedules 1 to 7. So now you'll say, sir, best thing happened, sir. We didn't take birth before 2013 law was enacted. Anna? Meaning, birth in the sense, I'm talking about CMA fine. Because otherwise you would be reading 1 to 658 sections. Now you have to read 1 to 470. For a kind information. When a new law comes, what will it do to the old law? Consolidate. Yes or no? In the old law, there will be things scattered. So what will they do? Consolidate. So what will happen to the number of sections? That's what happened. So few people who thought, oh wow, only 470 sections. They realize after reading, Baba, this law is lengthier than 1956. Plus, rules are there for everything. Chapter 9, you have seen 10 set of rules. So don't go by the number. Number is deceptive. Then other thing you see, earlier they used to have parts. Now they're calling it as chapters. So group of sections. Earlier parts, now chapters. Okay. Followed. Yes, sir. Now look at the preamble. What's the preamble of 1956? Consolidate and amend the law relating to companies and certain other associations. Okay. So when they wanted to bring this 1956, that time which law was there? 1913. Companies Act 1913. Then they got this 1956. So what did they wanted to do with 1913? They wanted to consolidate. They wanted to amend. Amend means only change. Addition, deletion also. Not just change. Addition, deletion. So they wanted to do that. Law relating to companies and certain other associations. What do you mean by certain other associations? Sir, LLP. But that time LLP was not there. Sir, partnership firms. Sir, foreign companies. Company law deals with those also, no? maybe to some extent, but it deals or not. So they said our idea of bringing new Companies Act is to consolidate the law relating to companies. That means sections, provisions which are scattered, they want to organize it, structure it, consolidate it, and only consolidation purpose they'll bring new law. Come on guys, answer fast. No sir, even amend, change, bring in some new thing or delete something which is not useful. That was the idea. Now 2013. Again they'll say, because 2013 time 1956 was there, so they said consolidate and amend the law relating to companies. Sir, they forgot other associations. No, I hope you know mathematics, indirect method or indirect that rule. A is equals to B, B is equals to C implies A is equals to C. So when we are saying in 1956, come on, certain other associations, then 2013 automatically it is included, no? Because what did they say? To consolidate and amend the law relating to companies. Relating to companies, which law is there? 1956, and 1956 is anyways talking about other associations, so automatically taken care. Now Subhashini will give me the answer or give me the preamble for 1882. Come on Subhashini, preamble for Companies Act 1882. Very, very good, perfect. Maybe we can clap for her. Good. Sir, there is some predecessor, because before 1882, 1866. So obviously this preamble will say consolidate and amend the law relating to companies. What about 1866? Same sir. What about 1850? Here we can't say, because that's the first law. So first law cannot say consolidate and amend. This common sense we have. Okay. So it can say regulate company form of business, isn't it? Okay sir, we got to know preamble of two laws. What is the meaning of the word preamble? Come on, I've told you, objective in short, or few people call it as long title. Section 1. Section 1 of 1956. First we'll talk about that. So what does it say? Title, the Companies Act 1956. Sir, you didn't write. I have written at the top, no? So once again I did not write. You know I am lazy. Yes or no? No sir, you are smart. Thank you. So we have written it again. Why should I write again, boss? Come on. So the Companies Act 1956 title. Next. Come on, let's complete it fast, guys. Extends to whole of India, provided state of Nagaland with some modification. That means this act was applicable to even Nagaland, but with some modification. Why sir? Because there was some treaty signed with China. That is why there were some modifications done. Sir, are we required to know all of that? No boss, not needed. Third thing, such date as central government may notify an official gazette. Three things were there. Now tell me, if let us say you are in 1956 regime and someone comes and asks you, we were registered under Companies Act 1882, are we also required to follow Companies Act 1956? What would you say? Where is it written? Not written. There was ambiguity. They didn't write that. They said extends to whole of India with modifications for state of Nagaland. But if you read now 2013 law, title the Companies Act 2013, extends to whole of India, then applies to companies incorporated under. Now if someone asks you this question, we were registered under 1882, you will show them, hey Babu Ikra, section 1. Section 1 already has written that it applies to those companies under previous law also, correct? Plus they also said it applies to insurance company, banking company, electricity company, or other company governed by some special act, or even some notified body corporate. So if central government wants to notify and mention some body corporate also to follow Companies Act, can they do so? Yes. Who is giving them the power? Section 1. So banking company is a company, no? Insurance company is a company, no? So banking company no doubt comes under the purview of Banking Regulation Act, even RBI, but then they also have to follow Companies Act. Same way, insurance company has to follow not just Insurance Act, IRDA Act and all, but also because they're a company. Now question comes, something is written in Companies Act, and on the same matter, something is written in Banking Regulation Act also, and it's a banking company. Now both this is different, meaning it's not matching. Which one the banking company should follow? Banking regulation. So that means banking regulation provisions will be overriding the provisions of company law. Same way, insurance company, Insurance Act, Companies Act, both are having conflict. Then which one will they follow? Insurance. Something is not written in Insurance Act. Okay, on a particular matter, provision is not there in Companies Act, but provision is there, not Companies Act, sorry, Insurance Act, but provision is there in Companies Act. Then they'll follow Companies Act, they'll follow. So your parent, your guardian, your parent, your guardian, whom will you listen to? Parent. Suppose guardian also says something and that is not matching, you'll say parent. Parent doesn't say something, guardian. Yes, same way. When insurance company, what is the parent law? Insurance Act. Companies Act become Guardian Act. Same way, electricity company, Electricity Act. Okay. So they're saying you have to follow company law, boss. No doubt you will follow your parent laws, but you also follow this because ultimately you're a company. Any conflict, then you follow that. Something missing there, then follow Companies Act. Here, you prepare financial statement for banking companies as per Banking Regulation Act. Good. Same goes with insurance and electricity. Because they say some other company also governed by special act, then that will also come. Okay. And even notified body corporate. So what do you mean by body corporate? We should have a clarity, no? If you are confused with body corporate, will it help? No. Sir, we know company, body corporate, company is not wider. Body corporate is wider. Body corporate. Okay, there's some body, there's some institution, there's some entity which is in corporate form. So can I say company is body corporate? Yes. LLP? Yes. Foreign company? They've clarified, yes. Companies incorporate outside India, they said we'll treat it as body corporate. That's why definitions are important. You ignore definitions and start reading the law, your understanding will be incomplete. I'll not say wrong, but incomplete for sure. And that is why your confidence will be lesser. So maybe I know we are taking some time to get into the topic, but then when we start understanding, you'll find we are able to completely understand, and that will give you confidence, and then automatically our pace also will go up. Once you are there on the pitch for some time, don't you think you'll know where the field is and how the ball is behaving, how the field is behaving, where the fielders are. So after some time when you are set, what will you do? Play your shots. Correct? Same way we will also do. Once we are set with things, automatically our pace will be fast and you will not even realize. You'll say, "Arey, this is the normal pace. This was required." Understand? So pace will change. That's where I was telling you, pace varies based on topic, based on your understanding. Correct? Okay. So section 1 we know. Yes or no? No, sir. Extends to whole of India. No Nagaland and all here. No modification. That means it is uniformly applicable to every state. Achha, why did they write whole of India? Sir, all states, all union territories, some territorial waters also, sir. Good. Understand? Next. What does this mean? Such date as CG may notify in official gazette. What does this mean? This line, such date as CG may notify in official gazette. Such date as CG may notify in official gazette. What does this mean? Sir, you are writing mathematical signs implies. Yes, I will use a lot of mathematical signs. Any problem? Even if you have problem, you can't do anything. Okay, jokes apart, but it will help us. That's why we use. Like this one, when I write change, delta, change. When I write this, equal to. So it becomes easy, no? We save time also. This is implies. So meaning when I'm asking, that means I want to know the implication. such date as CG may notify in official gazette. What does it mean? The law will not be implemented at one go, at one date, on single date. Such date as CG may notify. So Parliament gave the power to whom? Nirmala ji, MCA, that you decide. Which sections when, you note, and when you decide, you notify in official gazette. Official gazette is official newspaper released by government or government agency to communicate with public. Told you know, but nowadays it's not physical paper, it's the virtual way. Website is there. Clear? Followed? It's not single date. It means law is implemented. The act is implemented in phases. In phases. Right, sir. Achha, shall I say law or shall I say act? Sir, actually you should say act. But then we use these two terms interchangeably. We use these two terms interchangeably. Xerox, photocopy. I've told you, no. We use these two terms interchangeably. DIN number. Ain't DIN number ra. DIN itself means director identification number. So there's no need to say DIN number. Say DIN, it's enough. PAN number, say PAN, enough. Minimum quorum. How can you say minimum quorum? Quorum itself means minimum number of persons to be there in the meeting. But people use it interchangeably. So we also use it sometimes. Okay? Clear to you? So this comparison, did you understand? Preamble. Come on, guys. Hope. Out of those 1 to 29 chapters, do we have all? No. So tomorrow when we take up, I'll tell you what are those 1 to 29 chapters. See the list here. And I'll tell you which chapters we have to study, which is there in our syllabus. Okay? Same way, section numbers you'll get to know. Also, you'll get to know the schedules which we have in our syllabus out of 1 to 7. Section 1 anyways you got to know. So if someone asks you now, there is a company which was established under Companies Act 1850. Are they required to follow Companies Act 2013? What would be your answer? Yes. And if they say what is the source? Section 1. You'll say section 1 has said this. That's why we are saying. Correct? And if Nirmala ji comes up with now some date and saying that these provisions will come from this date. If someone asks how can she do that? What will you show? Section 1. Achha, CG means? Oh, is it? CG means central government. I didn't know this. Come on, guys. CG means you have to talk about MCA. Everyone knows CG stands for central government. All of us are in CMA final now. So we know it. So obviously, you have to understand I'm asking about ministry. Income Tax Act, when you read, CG means MOF, Ministry of Finance. PMLA will be reading. PMLA, Prevention of Money Laundering Act. CG means MOF, Ministry of Finance. Indian Partnership Act, when you read, CG word means MCA. LLP Act, CG means MCA. Achha, I talk about startup private company. Startup private company. MCI, not MCA. Ministry of Commerce and Industry. So CG meaning will change based on the act in reference. For now, that means for company law, it is MCA unless otherwise specified. Unless otherwise specified, because startup private company now only I have mentioned, it will be MCI. FEMA, when you read, CG means MOF, Ministry of Finance. So when we specify something else, otherwise it is MCA, at least in company law. Okay. So I know you are upset, you don't want me to end the class, but then every good thing has to come to an end, because something for tomorrow also there should be left, no? So don't worry, we'll meet tomorrow again to continue from where we are leaving. So thank you, God bless you, see you all tomorrow. Bye bye. Yes, bye sir, thank you, and take good care of yourself, boss, please. Yes, my dear YouTube live students, thanks to you too. Any concern, any doubt, please shoot, else we are ending the session. No? Okay. Bye, Naveen. Yeah, bye. Bye, Sumedh. Yeah, even I am glad. Thank you so much, Sumedh. Yes, Ishwar, bye. Thank you, beta.